With 15 pieces, they are saying 20 pieces.
All right.
Well, may I be permitted to mention for upgradation one matter, item number 172. Matter relates to compassionate appointment. I succeed in the before the learned single judge. State prepared an appeal in the year 2023. No step was taken, although there was a direction to give appointment to the post of NOMO. Non-official.
Please give the number. We'll upgrade it.
My lord.
You please give the number. We'll upgrade it.
All right. But great.
My lord, may I crave for your lordship leave to mention
Yes, sir.
MAT 944 of 2024, which has been listed as item number 38 of today's appellate file list. My lords, we are for the appellant in this matter. The company is a resolved company. My lord, your lordships had passed an order for stay against the demolition of the pipeline. My lords, the water is not being supplied properly to the factory. So we are only praying for.
Yes, we remember. We remember that.
Yes,
the municipality granted some.
Yes, my lord. We are only praying for this matter to be lifted urgently, my lord.
We'll upgrade it next week. So today there's some inconvenience for me. We will upgrade it next week.
Grateful, my lord.
Yes. You please inform the other councils also who are appearing.
We shall inform the other.
So that they should not be taken by surprise.
Yes.
Grateful.
My lord, may I be permitted to mention a matter? I am a petitioner in a review application in respect of the hoardings, the Bidhannagar Municipal Corporation hoardings, which my lord has directed to be brought down. I have filed a review application, and the main matter is supposed to appear tomorrow. My lord, may I be permitted that my review application be taken up along with the main matter? My lord, I'll provide the number to.
You provide the number. We will list your review along with the main matter. And have you served notice?
My lord, I am in the process. My lord, I have obtained the number today morning because of leave granted by my lord Justice Bhattacharya. Yesterday, I could get a certified copy. I'm in the process of serving. My lord, the matter is to come tomorrow, so I am only permitting it be listed. In the meantime, I will serve and come back, my lord.
Yes, you please serve.
Much obliged.
Your lordship, may I be permitted to mention a matter on notice? It's an appeal arising out of an order of this Honorable High Court for inclusion in the list. It's not running in the list currently.
What is the urgency, madam?
Your lordship, I'm the appellant and it's affecting my CIBIL score. That has to be changed. It's affecting my position to appeal for loans, to apply for loans. Your lordship.
You don't have any other remedy before the appellate tribunal, because CIBIL scoring. You are sure that you don't have any other remedy?
No, your lordship.
And your writ petition was dismissed?
Yes, your lordship.
Okay, inclusion in the list. Yes. Next week we will include.
Obliged, your lordship.
Your lordship, may I be permitted to mention a matter for correction of the of your lordship's order?
Yes, please. To be mentioned.
I'm grateful.
My lord, can number 124, WPP 29. I have already.
May I have your lordship kindly?
Yes, you please give that can number.
I've already given.
Next week it will be listed.
Malad, it is to be placed before the another bench where your lordship is sitting with Justice Patanayak.
Okay. You please inform the advocate. We have to constitute a bench, sir, with Justice Patanayak.
With your lordship, kindly may I permitted to mention the matter for restoration of application.
Restoration application, yes.
Lordship, I'm praying leave to move on appeal in the electricity matter, lordship, with a server copy.
Leave granted to file with server copy.
Have you applied for the certified copy?
Have you applied for the certified copy?
Not yet, lordship.
So you apply along with the photocopy of that, you file thereafter.
Yes, that will be the approach.
File.
Grateful.
Please apply for the certified copy.
Grateful.
Lordship, I crave leave to mention a matter. Lordship, I mentioned it last week, a GST matter wherein your Lordships were pleased to fix the matter yesterday for hearing. Item number 11, your Lordship, and the department, and my Lord had directed the department to adjourn the hearing till 14th.
14th, yes. Yesterday you could have mentioned, and urgent matters were given to our Lordship's bench, division bench.
Actually, your Lordship, the files we thought would not be there.
No. Once the urgent determination is given, if you take a mention before the other division bench, they would have definitely called for the file. So is it in the list today?
May I have your Lordship kind leave?
I'm humbly praying that, my Lord, if this matter can be taken up on Friday or Monday as per my Lord's convenience. My Lord, because the hearing has been adjourned to 15th by the department following the directions from this Honorable Court. I'm humbly praying if the matter can be taken up, my Lord, subject to my Lord's convenience, on Friday or Monday as.
All right, you please give the clip. We'll try to include it.
May I have your Lordship's kind leave to file one review application unaccompanied by certified copy? I applied for certified copy 3 months back. It is the order of Justice Prasad, division bench presided over by Justice Prasad. Kindly grant leave to allow me to file the review application unaccompanied by certified copy with plain copy of the order.
By Justice Prasad, now he is in the circuit.
Not sitting 2 to 10.
He's sitting, sir. He's sitting. He's not in the principal seat. He is sitting in the circuit bench.
That is, from there, his Lordship is not accepting. My Lord, kindly, my Lord, allow me, my Lord, to file it.
No, he can't accept it because the
I attempted when their Lordship was in Jalpaiguri bench, and my Lord sit on 1 p.m. my Lord for deliver one judgment. His Lordship says that no, it is not the time. It is only for delivery of judgment. Judgment, my Lord, delivered. My Lord, their Lordship raised, my Lord.
No. When did you file the review?
My Lord, December 2024, my Lord.
So you wait for a week.
My Lord, very urgent matter, my Lord. Review,
no. We can't, sir. The review.
3 months gone, my Lord. 3 months gone.
True.
It's a landlord's application.
That's true, sir. But then the review has to be heard by the Honorable Division.
Yes. That's true. But enabling just to file it. My Lord.
No.
Filing you don't require leave to file.
Exactly.
Yes, department is. No, my Lord. Filing section is saying, my Lord, you have to obtain leave if you insist to file the review application unaccompanied by certified copy.
No,
otherwise, my Lord, it is not.
You have to apply for the certified copy.
I applied, my Lord. File is not traceable since last 3 months.
So you contact the learned register administration.
Kindly grant leave. So
contact the learned register administration, saying that when you have applied, we will ensure that the certified copy is supplied expeditiously. Please contact the learned register administration.
My Lord. But already, my Lord, 3 months gone, my Lord.
Already, please contact. We will ensure that the certified copy is supplied expeditiously.
My Lord.
Lordship, may I permit to mention one restoration application for inclusion in the report?
Yes.
Lord, may I have your Lordship's kind leave, my Lord, to mention a public interest litigation for inclusion. So this relates to, my Lord, the election of the West Bengal Medical Council. Your Lordships were pleased to, my Lord, pass orders in this matter on previous occasion also.
Okay.
Lord,
please give the number.
Yes,
Lordship, may I
Lord,
permit
I shall. My junior will be.
Item 14,
I'm
Lordship.
Lordship,
may I permit to mention item 14, Lordship? Item 14, Lordship.
14 in the appellate side list.
Yes, Lordship. I am suffering from the grade 4 cancer. So some chemo, Lordship, some side effects. I want 3 weeks adjournment. So
you want adjournment?
For 3 weeks, Lordship. Grade 4 cancer, suffering from grade 4 cancer, Lordship.
Okay. No. This is an
chemo. I am for the.
No. This is an appeal filed by Eastern Coalfields.
Lord, I am for this company.
Oh, you are for the Eastern Coalfields. All right. All right. Item 14.
Grade 4 cancer, Lordship.
All right. Please take care. Adjourned. Item 14.
Your Lordship, I
3 weeks, Lordship. 3 weeks, Lordship.
3 weeks.
Lordship, 3 weeks, Lordship.
Yes.
Your
Grade
Lordship,
4 cancer, Lordship.
Your Lordship, I crave leave to mention another matter. Your Lordship, this is a writ appeal, Your Lordship, wherein we've challenged the 127 order transferring the jurisdiction from Kolkata to Raipur and Bhopal. Your Lordship, the affidavits are complete, but the item is appearing as item number 34. It was appearing yesterday in my lord's list on the appellate side. My lord, the difficulty is that the limitation for passing the order in case of the assessment proceedings under section 143.3 subsequent to search, Your Lordship, that will lapse on 31st March 25. Your Lordship, the authorities in Raipur, Your Lordship, they are now insisting that we proceed with the assessment.
All right, next week we'll try to take it up. You give the number.
My lord, I'm deeply obliged. I'm grateful, my lord.
Yes, sir.
Matter from the regular list for correction item number 1.
Sir, what is this? Year has gone.
Yes, the year is wrong. It should be 2017 instead of 2018.
All right, brother. You just dictate that order.
It has been pointed out that the year of the writ petition has gone down wrongly in the order dated in the order dated 16th of September 2021. The correct number of the writ petition is 30363 of 2017. First up, let such error be rectified. Let this order form part of the order dated 16th of September 2021.
Item number 2.
I'm appearing on behalf of the appellant.
It has been pointed out that there is a mistake in the year of the CAN application. First up, there were two applications, one being CAN 1 of 2022 and the other CAN 1 of 2020, CAN 2 of 2022. First up, it has gone down wrongly. Both the applications were registered as CAN 1 of 2022. First up, the second application should be read as CAN 2 of 2022. Let this error be rectified. This order shall form part of the order dated 9th of February 2023.
Another mistake, Malad, in this particular matter. Instead of MAT, Malad, in the last order, it has gone down as WPA.
No, no, it is MAT 621 of 2022. In which matter you are saying? Item number 1 or 2?
No, Malad, that is all right. All right, Malad.
Yes.
To be mentioned, item number 3.
My lord, I am appearing in person in this matter, my lord. My lord, in this matter, my lord, the appeal was admitted in the month of 13th May 2024, my lords, when your lordship was pleased to dismiss my application for interim order, stating inter alia that the elementary principle is that until and unless statute is remain valid, it cannot be stayed, my lord. So, my lord, my humble submission is that since the appeal was admitted and the hearing might take some time, and my patent is going to expire, my lord, in the month of May. So I have prayed for status quo of maintaining status quo with regard to the tenure of patent till the matter is being heard. If
that
I succeed in the
the problem is if you grant an order of status quo, it would tantamount to granting stay of section 53.
Yes.
No, my lord. My lord, my humble submission rests with.
No, what we can
recently...
do is advance your appeal for hearing sometime in February.
Grateful.
My lord, my one humble submission, my lord. In the places of Worships Act, the Supreme Court has recently directed all the courts that not to entertain any suits when the statute remain valid, because the Supreme Court is hearing the validity of various provisions of places of Worships Act. So so the elementary principle will apply. So the court has done to maintain the rights of the parties and to not so that it cannot be prejudiced. So court has directed all the courts to not to entertain debate. So my humble submission is that, my lord, in my matter, what has happened, that section 53 says that the tenure of the patent will be 20 years from the date of filing. But I have been granted patent in the year 2012 and my application is from 2005. So as an integrum, 11A7 says you will have a like privileges from the date of filing. So my lord, will the like privileges word is contrary to Article 14 of the Constitution,
That's
which
true,
grants
sir.
equal protection before the law.
Earlier two occasions matter were called on, my lord, learned friend took adjournment, my lord. And
Yes,
now,
sir.
My lord,
That
it
is-
was I was in an indisposable condition, my lord. I'm very sorry.
that is recorded in the order also.
Yes,
The
sir.
thing is, what we can do is we will list it under the same caption on
My lord,
19th February.
my lord, my injunction will go, and if I don't succeed,
No,
if I don't
you are
succeed, it will.
Mr. Sinha, you are unsuccessful before the single bench. And you did not have any interim order pending.
At any point of time. Grateful.
So
My
therefore,
lord,
the question, you know the legal position better. Okay.
My
List
lord,
the
I'm
matter
learning
under
from your
the same-
lordships. My lord, my humble submission rests with only to maintain the status quo with regard to the tenure. Nothing
sir.
else, my lord.
We have heard you, sir.
Mm,
We have heard you. List the matter under the same caption on 19th February.
Grateful.
Next.
Item number 4.
Grateful, my lords.
Item number 4, my lord, I appear for the appellant.
Yes, sir.
This is that matter, your lordships will kindly remember, an appeal was preferred against the issuance of rule of contempt by the single judge.
Yes.
There are several points I had the privilege to urge before your lordship, not only the question of doctrine of merger, because the other questions were also raised, that the learned single judge on the appreciation of the rules framed by your lordships court under the 71 Act.
And Mr. Sen also raised the question of maintainability.
Yes, I have raised the question of maintainability.
But today, there are several judgments.
Yes, but I will also have to cite some judgments.
Today it may not be possible.
Milord, kindly appreciate, Milord, that this matter was interim order initially was passed not to take any coercive order coercive steps. Then subsequently, on the last order, your lordships have been pleased to pass an interim order staying the order issuance of rule.
Yes.
Milord, this interim order has to be extended.
But I think lordship's order was subject to correction. In the meantime, respondents are not entitled to initiate any coercive action against the appellant.
No.
Mr. Sen, there is another order on 27th of November.
27th November order.
In the meantime, the order and direction issued by the learned single bench for the personal appearance of the Director General of CPWD remains stayed.
Yes.
So this has to be extended.
This order has to be extended, Milord, because 5 days delay, even if this order was remaining, the single judge has fixed the issuance of rule on personal appearance on Friday. Even if your lordship's order was there.
No, I was not aware of that, Milord. I was only praying your lordship will hear out the appeal until such time, Milord. The persons obviously will not appear, Milord. I can't say.
Kindly extend the interim order till disposal of the appeal.
We have heard the learned additionals also.
Kindly do not say till disposal. Kindly keep it next
week. No. See, we have seized of the matter. You have raised the question of maintainability. On 3 occasions we have heard. In spite of that, if suppose you are insisting upon the personal appearance.
No, I have not. I have not.
That may not augur well, sir. So under the threat of contempt, you can't, this is not correct.
No, I have never. We have not appeared also. We have not made any submission before the learned single judge. But kindly do not.
Heard the learned additions also, General, for the appellant.
But in fact, we have placed your lordship's order before the learned single judge.
And Mr. Sen, learned senior advocate for the respondent.
I have never pressed anything.
All right. The order of stay granted on 27/11/2024 shall continue, and the personal appearance of the Director General of the Central Public Works Department, New Delhi, shall stand suspended till we hear out this appeal, in which several issues are being canvassed by the learned advocates appearing on either side. Let the matter appear under the same caption on 5th February.
Very well. Obliged.
Yes, sir.
Careful.
Well,
Item number 5.
we should let it be understood. We shall argue the matter on that date itself.
Yes.
Obliged.
Under the same caption immediately after fresh cases.
Obliged.
Item number 5 with 6.
5 and 6.
Yes.
I appear on behalf of the appellants. I beg to assist your lordships online.
Oh, very good. I'm also online.
We are appearing for the respondent, my lord.
Now, my lord, here, my lord, this is an appeal, my lord, against rejection of review. But on the last occasion, my lord, a point was raised by learned friend appearing for the other side, as well as
whether it's a judgment within the meaning of clause.
Right. Well, we need to, my lord, address your lordships, my lord, extensively on this.
Yes.
My lord, I am prepared with it, my lord, starting from Khimji's judgment. If your lordship permits, my lord, I can address your lordships today itself.
Not today.
My only urgency is, my lord, there is a threat of contempt.
No, that
may I just indicate to your lordship?
That will not insist.
The contempt arises out of the main order, not out of this order passed in review petition. So, my lord, in this matter, my lord, they cannot pray for stay of contempt proceedings, subject to correction.
Will not the order in the main matter merge with the order in the review?
My lord, the review petition has been dismissed. And my lord, whatever order was passed in the original petition, but that the writ petition, but that order stands there, my lord, not interfered with.
There are two appeals.
One by the state, another by WBIDC.
All right. If suppose they file another appeal against the main order.
But the main order appeal has been dismissed.
No, not dismissed.
By your lordship.
It is not dismissed, my lord. Your lordships were
it has been dismissed by your lordships. And my lord, the honorable single judge, when this point was taken before the honorable single judge, that my lord, your lordships has granted leave to move review petition. The honorable single judge, by a separate order, clearly observed that no leave has been granted by your lordships.
My lord, your lordships may kindly have a look to the previous order at page 204. Please have a look to the previous appeal court's order, my lord, at 204.
This would be item number 6. WBADC's appeal is item number 6.
Lord, please take, my lord, the file in item number 6. I'm so sorry, my lord.
204. Yes.
204. Lord, against the first order, my lord, when we prefer this appeal, please have a look to the second paragraph. On going through the impugned order, we find that the learned writ court has recorded that the writ petitioner was entitled to refund of 90% VAT and CST, which was paid by them. And despite several requests, the appellate authorities were not refunding, despite the scheme being in force, so and so. Now, please take the fourth paragraph. Before us, the state seeks to argue the matter on merits and contend that the respondent writ petitioner was not entitled for refund of 90% VAT and CST. If that be the case, the appellant should have agitated such an issue before the writ court. Therefore, appeal is not the appropriate remedy. This is what your lordships have been pleased to, my lord, observe in the 5th paragraph. And finally, in the 6th paragraph, it is dismissed. And, my lord, there was a appellant seek to review the judgment and order, if so advised. Therefore, my lord, we go back. My lord, the certified copies are returned. We go back to the learned single judge. Now, my lord, this learned single judge, my lord, today passes an independent order, my lord, rejecting all the points that we have taken. Good, bad, indifferent, that is another thing. But, my lord, today, my lord, the review order, my lord, if your lordships may kindly have a look to, my lord, page 228.
Well, I would beseech your lordship, I will also request the learned advocate general to place before your lordship an order passed by the honorable single judge when this point was taken that this review petition has been filed pursuant to the leave granted by this honorable court. The honorable single judge specifically held that no such leave was granted and this review petition
No,
is.
we didn't grant leave. We said it is well open to the.
Yes.
That was only an observation. That is correct.
That was only an observation.
I don't urge that a leave was granted by the court. But I have, my lord, gone.
Now, one thing, Mr. Majumdar, now the review application has been dismissed. What is the remedy available to the review applicant? He can't be remediless.
The remedy available to the review applicant would be, my lord, in my most respectful submission, if no intra-court appeal lies, then only remedy would be an application under Article 136.
But I'll address your lordship on that, my lord. Where Khimji's judgment is clear, my lord, there are other judgments, including, my lord, the latest judgment of the Madras High Court full bench. My lord, Justice Bhattacharya was also pleased to, my lord, do some research work. My lord, I need to, my lord, get over those judgments also.
In any event, my lord, today the state
actually the matter was, I think,
direct answer to this point in our previous judgment. That is also three judges bench of our court.
Yes.
Or one suggestion to both of you.
Yes,
if you want continuity, we can place it before the division bench of Justice Honorable Justice Harish Tandon and Justice Bhattacharya.
But I have no difficulty, but my lord, only some assurance that the contempt will not be.
My lord, rule has been issued. They are supposed to appear on Friday.
No, definitely will appear. We can't
appear on Friday.
No, you can appear and say that
there is no prayer for stay of contempt proceedings in this matter.
Because the Honorable Division Bench has taken note of the decision of the full bench of the Madras High Court, plus the big compilation which you have filed. I think for continuity, and their lordships are also hearing two other matters on this scope of clause 50.
I see.
Two other matters is also running in their list. So I think it is better that you address that bench so that you may not start.
May I just subject to lordship's kind consideration? My lord, my lord, they are supposed to appear personally on Friday. My lord, Friday, obviously nothing will happen. They will cause their appearance and whatever will the due course will be.
Sir, now what is the direction?
What I am humbly submitting, may I take instruction from my client that whether we would pursue this point of maintainability or not. Because, my lord, we are more interested in getting the relief right now.
Exactly.
But, my lord,
that is commercial prudence.
That is commercial prudence, my lord. That is commercial prudence. So, my lord, kindly keep it on some other day. Let me take a written instruction. If my client wants to proceed with this point of maintainability, obviously we will go to the other bench. If my client doesn't want to proceed with this issue of maintainability, then, my lord, the matter can be heard on merits. I think that is what state wants.
Sir, now 90% of the amount has been refunded, correct?
No, nothing. Nihil. 260 crores, nothing.
Then I think it is better you argue on merits, sir, instead of this contention.
My lord, kindly give me let me take instruction. My lord, I have to take instruction of my client.
Okay.
We'll take written instruction.
You better take written instructions. Huh?
Yes, my lord. That is what I instructed my learned advocate on record.
Yes. We have heard the learned advocate general appearing for the appellants and Mr. Majumdar, learned senior advocate, appearing for the respondents. When the matter was heard by the Honorable Division Bench on 16/12/2024, it was observed that an interesting point is raised in the instant appeals by the counsel appearing for the respondents, whether an order rejecting an application for review is a judgment within the meaning of clause 15 of the letters patent. Full stop. Another ancillary point is whether the rules framed by the High Court to regulate its proceedings can override the provisions contained in the letters patent. The matter was adjourned to enable the learned counsels to address arguments and place judgments in support of their contention. Today, Mr. Majumdar learned senior advocate appearing for the respondent submitted that the counsel on record for the respondents may be granted time to get written instructions from their client as to whether they wish to pursue the point regarding the maintainability of the appeals and to address arguments on the merits of the matter. Full stop. In the light of the said request, let the matter appear under the same caption on so and so date. Full stop. Since the matter has been adjourned for the aforementioned clarification, we would request the learned advocate appearing for the respondent not to pursue the not to press for the personal appearance of the authorities.
Well, that has already been issued. My lord, rule has been issued.
Oh, rule has been issued. Then you leave it.
They will appear on Friday. But my lord, we will inform.
May I make this request?
We will make a joint. We will make a joint paper. I will not stand in the way. We will.
Because it is not going to help. The chairman may come and appear. Probably he will come and see our High Court. In what condition we are all operating.
They have to come and see the High Court on that day in respect of two matters. So, and both are incentive matters.
Could I make this request? Miller? If this can be modified, I'm hesitant to make this prayer. Kindly permit them to appear online. That will serve the purpose.
We'll make an observation. We can't
Let them appear, my lord. I can assure the learned advocate general. I will inform the honorable court what has happened. I will inform them. Let them appear. Because, my lord, because that will amount to stay of rule, my lord. That is not permissible. That
kindly do not observe anything. Kindly do not observe anything.
We will inform the court. We will inform the honorable court.
All right.
Very.
You give a convenient date to both of
you. Your lordship is making this matter returnable next week, my lord. We have some urgency, my lord.
Definitely, whatever date is convenient.
Your lordship, my lord, whatever date is convenient to
any day, next week.
Any day. Because if we decide to get the matter heard on merits, my lord, it will not take much time.
Then 15th January.
Very well, man.
Mr. Mojumdar, only one clarification. Even if you do not press the issue of maintainability, if it goes to the root, whether the court can enter into the merits without deciding whether the appeal is maintainable or not, even if you choose not to raise that issue of maintainability.
That is an issue, my lord, because my lord, because by consent of parties, my lord, neither the jurisdiction can be conferred on court or jurisdiction, the court can be divested of jurisdiction.
So this is the question of jurisdiction.
Yes.
Whether the court can take up. So if the jurisdiction is not answered, merits cannot also be entered into.
Let me come back with the instruction. Then I leave it to your lordship. But I am ready with the review. I am ready to address on Babulal Khimji. And my lord, I will address
because there will be another effect
of Babulal Khimji.
There will be another question because the state has not challenged the parent order. If Mr. Advocate General's argument is accepted, that the earlier order passed by the division bench, there is no merger because nothing was decided. The original order remains intact, unchallenged.
Right.
So rejection of a review, they have to challenge the parent order. So if the learned Advocate General's argument is accepted, then the original order revives and remains unchallenged. So these are
I understand, madam.
So maintainability on both grounds are in issue.
I understand.
Because they have not challenged the parent order.
Right.
Well, Mr. Madhundar, I think you caught the tiger by the tail.
My lord, I do not know, my lord. All I am interested is that the matter should be disposed of at the earliest. That is my only interest in so far as this matter is concerned. My lord, grateful. But I will come back, my lord. I will address all the issues.
The other incentive matters were all affirmed by the Supreme Court. Whether those decisions will have any effect?
Yes. No. These are special category case. These are special.
No.
Those are special category case. This is not a special category.
But here the point is slightly different. Here the point is, my lord, company A had applied. Now company A does not exist. It has merged into company B. Now whether company B can inherit the rights of company A under the scheme. That is the point.
But then if a scheme of amalgamation has been approved with the company court, then they step into the shoes.
Madam, may I just put it in this way? But in one line, what is the matter about?
In case of the fixed assets being taken over or purchased or sold by the company applying, a prior permission has to be taken.
My lord, may I just indicate to your lordship, the scheme says that in case of change of management or change of transfer or some kind of amalgamation, information has to be given to the authority.
No. This is where, my lord, we differ.
Permission has to be obtained. Let me put it this way. Let me put it this way, that permission has to be obtained by the authority. Now, my lord, the prior permission as contended by the state before the amalgamation was not obtained. Not obtained. What was the company, the new company informed the state authorities about this change of management by several writings. In the review petition, the state says and the WBIDC says that they were not made known about this change of management until this writ petition, the original writ petition, was filed. I demonstrated from the records available, as well as from the souvenir or the brochure released by this WBIDC for this Bengal Global Business Summit, which is held every year, that they showcase our project as one of the key projects in Bengal, as to convince the investors that Bengal is a good destination for investment. What is the matter about?
Now, sir, one more thing. Before a scheme of amalgamation or merger is approved, the registrar of companies
it's an in rem proceeding that's fallen from my lord. It's an in rem proceeding.
So what happens is, all stakeholders are put on notice.
Right.
All departments of the government, including the income tax department, is put on notice.
Right.
So if anybody wants to put in, see, the thing is, a scheme of amalgamation is something like a probate proceedings.
Right.
Yes. So if a person can always challenge, a petitioning
advertisements
creditor.
are issued, my lord. Advertisements are issued.
Advertisements are issued. Even assuming a scheme is approved, a petitioning creditor will be entitled to approach the company court for reopening the issue.
Right.
So therefore,
they can approach. They can definitely approach.
So therefore, one is ROC will file a report before the company court.
The learned judge was at one point of time during the course of hearing, because of a statement made by the WBIDC on oath, the learned judge was minded to initiate perjury proceedings. I intervened. I convinced the honorable judge that this is not. Don't initiate perjury proceedings. It may be a mistake. This is what has happened.
The learned single judge proceeds on the basis that it is a change of name. The change of name is under a complete different proceeding. Paragraph 21 of the judgment under review.
No, whether it's a change of name or a change of management, approving a scheme of amalgamation or merger, public notice is given.
Yes.
Public notice is deemed to be proper notice to all stakeholders.
Yes, I am not a stakeholder, my lord, in respect of that.
State is a stakeholder.
State is a stakeholder.
State is a stakeholder.
State is not a creditor, my lord, over there under the scheme. State is not a creditor.
Always a stakeholder.
No. They are stakeholders in the sense they can always put the spanner in. They can say, no, sir, we have extended the benefit of this scheme. The successor company will not be entitled to. Probably West Bengal Industrial Development Corporation might not have noticed it or ignored it. But the fact remains that the company was enjoying the benefit of the scheme is well known. It's no secret at all. It's well known. And once the company merges with something or there is a change of name, everything there is a public notice. Probably it's too late in the day for the state to come and say that they were not aware of the proceeding. Assuming
my lord, I got your lordship's point. But here, my lord, the appointed date is 1st of January 2015. Amalgamation appointment date. But my registration certificate, the first one is subsequent date to, that is 24th of April 2015. Therefore, the entire scenario changes. Therefore, as on date, my lord, I had issued the certificate in the name of company A. But on that day, by fiction of law, company A did not have any right. It was company B who had, by fiction of law, stepped into it. Therefore, how can a certificate issued in favor of company A subsequent to amalgamation into company B, thereafter company B comes and says that whatever certificate you have issued in favor of company A, give me the benefits, I am company
But my
B.
lord, the date of the order
Yes,
is subsequent to
very
the date.
important. Therefore, it's very important.
So the appointed
Maybe the effective date is something else.
Yes, effective date or appointed date is by convenience of the amalgamating companies.
Right.
But what will be relevant is on what date the scheme was approved by the company.
Yes, well, that was
Before
subsequent.
that, there is another date. I assume for argument's sake that I may not succeed on this point. Milord, now the board, Milord, approves the amalgamation on 5th of November 2016, whereas my RC2 is on 20th of March 2017. Now on 20th of March 2017 also, before that they don't come and say that we have already approved of the amalgamation, our board.
The approval given by the board is placed before the company court, NCLT.
Definitely, but not before me.
The approval by the board is it's the first step.
Yes.
To proceed with a scheme of amalgamation.
Right.
But all right, we'll address. Let Mr. Marmoda's
I'll come up, Milord, with a list of dates for your lordship.
Well, we will also come up. Well, our list of dates may match also.
Yes, sir. Next.
I'm grateful.
Item number 7.
Lordship, item number 7, my lord, I am appealing for the appellant writ petitioners. My lord, before I start with showing the papers, in a nutshell, I'll tell you what has happened. I was a borrower in the bank, in respect of a housing loan. Now, I took the housing loan. Subsequently, I took a AAA loan based on the same security, which was my flat, against that housing loan. Now, it so transpires, there is another partnership firm which had taken, working capital demand loan, as well as, another demand loan, for which, they had furnished certain securities which are, belonging to that partnership firm. The fact is, there that, I am, one of the, I am, wife of one of the partners of that partnership firm. The fact is, I, never, furnished my particular flat as a security for securing the working capital loan and the demand loan by the partnership firm. In spite of the same, my property was first taken symbolic possession, subsequently physical possession was taken. At the time, in my paragraph 20 of my stay application, I have stated I was not in the Calcutta, I was in Bangalore. It did not, the information it was there, it did not, I could not take steps. Subsequently, it was not served upon my address. Subsequently, we have challenged, the now, what happened? The bank, in their 9 points affidavit under Section 14 of the SARFAESI Act, furnished the wrong information to the learned magistrate. Lordship, in
District Magistrate.
District Magistrate, my lord. Under Section 14, my lord, acting under, my lord, that is, my lord, there. My lord, I know it's a ministerial step, but, my lord, by way of amendment, my lord, a proviso was introduced by which, my lord, the 9-point affidavits were introduced. My lord, what was, my lord, the requirement of the statute? My lord, I'll show to your lordship, my lord, that the magistrate had to record a satisfaction to the effect, my lord, the correctness of the facts which were furnished, my lord, in terms of that 9-point affidavit by the bank. My lord, in that 9-point affidavit, my lord, the bank wrongly, my lord, described my property as a property which was pledged as a security in respect of the working capital loan. My lord, it is true, my lord, my property was pledged in respect of a personal housing loan, and it's in a different capacity. My lord, that particular, my lord, security was never extended to the loans secured by the partnership firm.
But why did you file a writ petition?
My lord, I'll come to that, my lord, because my lord, I have, my lord, bank, my lord, initiated initially, my lord, even, my lord, I'll come to that, my lord, because, my lord, my rights, my lord, are being affected, my rights of property are being affected, my fundamental rights are being affected, and, my lord, the statutory remedy, which is there under section 17, my lord, which, my lord, in my, my lord, humble submission, is, my lord, the coordinate bench of this court, my lord, as well as, my lord, the Supreme Court, my lord, I'll show, my lord, some decisions of these, my lord, courts to show, my lord, that in case such a situation has happened where, my lord, a wrong information has been submitted by the bank, which resulted has been, my lord, in dragging off my property in respect of a different loan. My lord, in that case, my lord, respectfully, my lord, I did not go to the DRT. My lord, this honorable court, a coordinate division bench of this court, my lord, has held so. My lord, I'll show to your lordship.
We have held otherwise. We have held otherwise after considering the very recent decision of the then Honorable Chief Justice of India. I think you should be carrying that judgment also. Sir, you may have an excellent case on merits. The earlier there was a doubt as to whether a tenant in a property would be entitled to go before the debt recovery tribunal under 17. Then whether an issue, a land is an agricultural land or not an agricultural land, whether that can be raised before the tribunal because the bank does not, SARFAESI Act will not apply. Then Supreme Court has clarified that these are all issues because in 17, section 17, it uses the term any person.
I'm grateful.
Person who is in occupation of the property, maybe by way of a lease, by way of a tenancy, or he could have been even a trespasser claiming, or some part performance might have happened. Number one. Second is whether the documentation executed by the present appellant in favor of the bank would cover properties which were not subject matter of mortgage also. Thirdly, whether the bank can exercise a banker's lien in respect of the property, because so far as they are concerned, earlier, of course, you know the law better. Earlier, what they said is,
my lord,
first you will have to approach the principal borrower. Then if a principal borrower is the company, then you come to the directors, then you come to the guarantors.
My lord.
Now that law also got diluted, and what they said, it is up to the lender to choose against whom he will proceed first. In your case, probably yours is the most easily approachable, liquidatable asset available. They have approached. So the best thing is if you had, because day in and day out we have been seeing orders of debt recovery tribunal setting aside orders under 14. It is a very good forum before which, because they are a specialized tribunal. And if you can approach them, quashing 14, as well as saying that this was not a mortgaged asset, the documentation will be called for, and you can always succeed in establishing the fact.
My lord, I have followed. My lord, I have tried to follow.
What happened to your writ petition?
My lord, it was relegated. My lord, the honorable court, my lord, was of the view that I should approach the forum under the, my lord, the DRT under section 17.
Rightly so.
My lord, it is at page.
In fact, the honor.
My lord, I'll try to pursue your lordship, my lord, on certain points. My lord, number one, my lord, when, my lord, the district magistrate, my lord, is exercising its power under section 14 proviso, my lord, it's a statutory power. My lord, I appreciate it's not a judicial forum, but at the same time, my lord, it is an administrative forum. My lord, it is doing a ministerial step for which, my lord, the Supreme Court has categorically held in 2023 that, my lord, it has to look into the correctness of the information which were furnished by the
all right.
bank.
You have accepted it is a ministerial act. Assuming this order has to go, does it mean to say that the property will revert back to you? Don't.
My lord, in fact, my lord, that was what was held by, my lord, this honorable court's my lord, coordinate bench. And, my lord, even in Supreme Court in 2016, my lord, Supreme Court had categorically held, my lord, if you am aggrieved by, my lord, an action under section 14, my lord, the right forum is to approach this honorable court under article 226.
No, I think
but I'll show that judgment to your lordship, my lord, subject to, my lord, today, my lord, lordships are not sitting, my lord, physically. My lord, I have the bunch of papers, and, my lord, I have to also, my lord, file a short supplementary affidavit disclosing some documents which are already a part of, my lord, but the bank, my lord, had filed before the SARFAESI process, my lord, they had also filed an OA under the RDDP Act. My lord, that, my lord, I am just, my lord, few pages, my lord, extracted from there on. which shows the bank has itself admitted that those are not the particular securities furnished in respect of the working capital loan.
You do that, we'll grant you leave. You make the compilation ready and probably exchange soft copies with your friend. And you also go through our decision.
I followed. I'll try to, I appreciate, my lord.
The court officer will be able to give you the number. But I don't know whether they showed this coordinate bench decision to us.
My lord, 2014, my lord, Devoshree Dash. I'll, my lord, submit, my lord, the copies.
We forget who appeared in that matter.
My lord, I'll just try to indicate.
Sorry, the quoted
My lord, my lord.
In the judgment, Saikat Banerjee, no, not Saikat Banerjee. That was sometime, I think, in November, October, November.
October, November, 2024.
2024.
Yes, 2024.
My lord's judgment. Yeah.
We heard the matter extensively in that recent decision of the Honorable Supreme Court was also placed before us. We dealt with that issue also.
My lord.
Mr. Pathak, do you remember that case?
I'll check it up and provide.
In
course of this day, I'll give you.
Once again. I think Mr. Ratnokar Banerjee appeared. This could be the matter.
My lord.
HON'BLE property in Salt Lake. You just check up this number, MAT 483 of 2024.
My lord.
We reserved judgment on 13th of May 2024, probably delivered it a week thereafter.
My lord, my lord.
Axis Bank versus Indian Cable.
Indian Cable, my lord. Very good.
Judgment copy does also.
483.
MAT delay. MAT 483.
483 of 2024. Where RBI Act extensively they argued.
My lord.
And Mr. Sabishashi Chaudhary, he appeared for the writ petitioner. Now the designated senior. They cited one 2023 SEC Online Delhi 6970. That was the latest.
My lord.
And there's another decision where we considered the recent decision of the then Honorable Chief Justice of India. It's a very elaborate judgment.
My lord.
I'll try to get that number if possible. You check up this one. Axis Bank is the Indian Cable.
My lord, I'm grateful. I'll do that.
Yes. Thank you.
Now, my lord, only thing is, understand, my lord, a sale notice has been issued. Although, my lord, it has not been served upon me. My lord, the course of, my lord, the mentioning the other day.
At least you can now challenge the sale notice and pursue this appeal separate.
My lord, my lord, what has fallen from your lordships, my lord, definitely. But my lord, I'll try to pursue, my lord, I'll try my luck once, my lord, before your lordship. My lord, I think, my lord, I have a good case. My lord, I'll try to pursue your lordships.
No, that's correct. In fact, we have been seeing a lot of orders passed by DRT. Invariably, the borrowers are successful against orders under 14. Invariably, they are successful. They have not come to us directly. In fact, in one case, party in person, Kohli. His name is Kohli, some Kohli. He was able to say, we dismissed this appeal. Writ petition dismissed, appeal dismissed, review dismissed. He was able to obtain an order of stay from the DRT.
My lord. My lord, that, my lord, I'll try to address, my lord, on the point of alternative remedy, my lord, also.
No, we are just thinking aloud, nothing else.
My lord, I am grateful, my lord. I get, my lord, the food for thought.
So we fix it up on 22nd. Same position.
I'm grateful.
May I indicate only few things? Firstly, I represent the bank.
Yes.
Firstly, the very premise on which my learned friend seeks to approach this court is that the order or the property which they say was not extended in the main account is probably not correct. My lord, my specific instruction is that even in we have disclosed documents in the original application which goes to show that this property was also extended in the main account. And even then, the property in question is also mortgaged to us in a separate account. It is not that this property is not available to us. It is. And again, my lord, the present writ petitioner appellant's husband, my lord, in the cause title, he has not used the name of the husband. Anyhow, the husband went.
So I've said so.
The husband went up before a Section 17 application, challenged the same order of the ACJM, and the interim order was refused.
So that application is still pending?
Yes, that is still pending. And in the single bench also, the Honorable Single Judge had opined, though not reflected in the order, that you can yourself get added as a party in that same proceeding.
Anyway, it's up to them. No, we'll hear the appeal. We'll list it on 22nd.
My lord, in the meantime, my lord, may I, my lord, file the supplementary affidavit, and my lord, I'll serve a copy upon my lord.
Yes, leave granted to file supplementary affidavit.
We should not be restrained from proceeding.
Pardon, sir?
Well, we should not be restrained.
Nothing at all. We have not said anything.
Lord, we have found out the judgment, my lord.
That is not this
on 10th July 2024.
July 2024.
10th July.
10th July.
10th July.
This is Axis Bank Limited versus Indian Cable Net Company Limited and others. Well, I am handing up the copy to the learned advocate.
Okay. And there is one more judgment that
I'm grateful.
We'll give you. Yes, next.
Item number 8.
Item number 8, may I pray for only a short passover, my lord?
Not today, sir.
My lord, I am appearing for the respondents.
Oh, yes, sir, Mr. Gupta.
My lord, only not today then, my lord.
Only not today.
My lord, I have difficulty tomorrow, my lord. Kindly make it next day, my lord. My lord.
No, it won't come tomorrow.
My lord, my lord.
Tomorrow is original side day. Next.
Item number 9.
My lord, 9 is my appeal. My lord, we are against an order, my lord, which has been passed, my lord, exceeding, my lord, the prayers made in the writ petition, my lord. My lord, the writ petition was filed for execution of a deed of conveyance. Your lordship will find the prayers at page 59. My lord, before taking your lordship to the impugned order, kindly takes, my lord, page 59 once.
Execute the deed of conveyance. So
conveyance. My lord, there was an allotment made by my client in the favor of the mother of the writ petitioner. The mother died, my lord. In the meantime, my lord, the conveyance could not be, my lord, executed. And there were inter se discussions and deliberations between the parties. I'll take your lordship through that. That's, my lord, in the merit of the matter. Because they suggested some changes in the draft deed. My lord, we being a government authority, we were not being able to accede to such demand. Because, my lord, it's more like a dotted line, my lord. It is same deed for everyone. They wanted some changes, so it could not take place. But this is the limited prayer in the writ petition along with a prayer for cost. The prayer for cost is at page 61. And other apartment ownership, etc. My lord, we are not concerned with that. Now, my lord, kindly comes to the impugned order once. That is that in the stay application, it is starting from page 283. If your lordship, my lord, for the time being, kindly takes from paragraph 15 of the impugned order, that is at page 289. Now, my lord, the honorable single judge has allowed one point of ours, which was our point of defense, that the right we have acquired from the state government is for not to sell the property, but we can only give out in a lease of 99 years. This point has been accepted by the honorable single judge. But in spite of accepting that point, the honorable single judge has gone on to direct us to change the leasehold land into freehold land, then not to take any registration charges from the person, now not to take any stamp duty from the person. These are all beyond the praise. I'll read from paragraph 15 onwards to give some coherence to my submissions. Kindly takes from internal page 7, paragraph 15. May I place it, my lord? May I place paragraph 15?
Once again, sir, how can you now, in a writ petition, pray for a change of the character of transfer? If it is a lease, you have accepted, you have applied for a lease, the application letter of allotment issued, lease deed executed, not executed or executed. Now, whether the writ court will be able to say that you will become an absolute owner, the property will be a freehold.
But that is why the writ petitioners did not pray for it. But the honorable single judge has gone beyond the pleadings.
No. Are you ready to execute the 99-year-old year lease?
Yes, but yes, I am ready, but not in terms of the clauses that the writ petitioner is suggesting. In terms of the clauses which is there for everyone.
No, we'll ask your friend. Sir, you better accept the 99 years is virtually a lease in perpetuity. You see all the Salt Lake properties, all illegally transferred, though leasehold, cooperative, some fellows have purchased, demolished, reconstructed. It will be very prudent for your client to accept a 99-year-old lease.
My lord, may I submit one thing? Your Lordship, kindly turn to page 67 first. Then I will ask your Lordship to look into the brochure by which they valued me to part with the money and book that particular flat. But your Lordship, kindly, my lord, page 67. What happened? My mother was allotee. Then he paid entire amount. Entire amount. And my lord, the draft was prepared for my lord, the sale, for execution of sale deed. But my lord, in the intervening period, my mother fallen ill and he executed a gift deed in my favor. And my lord, before execution of that transfer deed, my lord, my mother succumbed. And my lord, then my lord, I started running after them. But your Lordship, kindly page 67. My lord, this is the judicial pronouncement. My lord, and that is also at the instance of the my learned friend's client. That succession certificate has to be produced by the petitioner.
Correct, sir. This order says.
But how? But I'm asking myself. But how a succession certificate can be against the immovable property? But I'm asking myself. And
succession certificate also include the names of the legal heirs. Probably succession certificate or legal heirs.
Your Lordship, kindly see. And 2008, I obtained the probate. I produced that probate. Despite production of probate, they carried on the insistence of getting a succession certificate. And 2013 to 2018, they refused my claim because they have banked upon the succession certificate. But how can it be a succession certificate in respect of a flat that is an immovable property? But this is the functioning of a statutory body. And after due effort, I could make them understand through the communication made by
Mr. Bandapati.
Your Lordship,
No, 1 second. Mr. Bandapati, please see. The order passed by the government of West Bengal Land Policy Branch is in the year 2012, which says it is a 99-year lease. Whereas there is a
but then I'm coming, my lord.
This point has been decided against my learned friend. It is not his appeal. He has accepted that point.
Your Lordship kindly sees, my lord. My mother paid entire amount in 2001. Got possession.
But
sir. The document was not executed. Why it was not executed, my lord? Your Lordship kindly turn to, my lord, to the brochure. How they have allured me.
No, sir. One thing.
But page 136,
Sir,
your lordship kindly peruse, my lord.
Here, sir.
Page
Paragraph
136.
Please hear, sir, once again. Paragraph 15 to 17 is a finding which is against you.
And 21
you
also.
are not.
And 21 also.
Assuming
He has not preferred an appeal from the order. He
Malad,
cannot take these points today.
Malad,
Kindly seize 21.
Assuming, my lord, they have taken a plea of delay. But how I am responsible for causing delay? I am not responsible because they, since Malad 2003, they are threatening me with the succession certificate. But your lordship kindly come. He has not
You
preferred an
can't,
appeal.
sir. You can't argue that point, sir. Please come to para 21.
I got your lordship's point, but only I am confronting the cause of delay. And since
I'll place those.
they caused delay in executing the document, that's why this relief was extended to the petitioner. But
paragraph 23 first paragraph alone we will confirm. 2 and 3 will have to be deleted. It cannot that's a separate independent cause of action and for you to pray for.
Also, my lord, the paragraph. One second, sir. Also, my lord, the paragraph which is after the heading later. My lord, after the passing of the order, another direction has been given, internal page 15 of the order, where I have been debarred. I have been asked to take a stamp duty on the date of allotment.
Sir, we can do one thing. These orders can be set aside right and now. We can confirm 23 subpara 1 and direct them to execute the document within 4 weeks.
My lord.
Your lordship subject. I would like to challenge this particular writ petition, the stay application because of the fact. But because of the fact, your lordship kindly consider.
All right, you file an independent appeal.
Your lordship, before passing any order,
we will. Otherwise, you will move for contempt. If you want, we will direct.
Contempt is fixed on 20th January, It's the third day.
This order will remain stayed. Sir, be satisfied with subpara 1 of para 23. The remaining paragraphs will remain stayed, including the portion later that also will remain stayed. Or you want right and now, we remove these directions alone, confirm 23(1), and they will execute the lease deed within 4 weeks. Thereafter, if you want, you seek for the converting into freehold, etc. It's a separate cause. It's beyond the scope of your writ petition, sir. Sir, please advise your client properly. It is worthwhile to get the lease deed in your client's name, right?
Your lordship kindly consider how KMDA is affected when the exemption in respect of the stamp duty has been made. But KMDA
that was not your prayer, sir. That was not your prayer in the writ petition.
But my prayer was, the writ petition was this, that inordinate delay and the change of terms, because in 2012, they detected that it should be a lease deed. Prior to that, all the time, they were of the impression that they will execute a sale deed in my favor. But your lordship, you
file an independent appeal, let us see.
Your lordship, kindly come to my page 142 once.
No, not today. Not today. You file
it starts from our page 136. Your lordship, kindly turn to page 142. But how I get that right? Unless I get that right, but your lordship, it starts from 142, 36, and 142 documents for transfer of apartment on payment of full sale proceed. But accordingly, I had paid entire sale proceed, and what was their obligation? Subject to other conditions prescribed herein, the apartment shall be transferred by the CMDA to the allottees by way of outright sale after payment of final amount. But they have not done anything despite collecting entire consideration. And they then started saying that bring succession certificate. And this process continuing since 2007 to 2018. Then 2018, they accepted that yes, name can be transferred. Then what they said, now we have decided because government has not transferred the right to us to sell out that property. Therefore, we are going to lease out that property. And then they have changed their stance in order to
this argument was rejected by the learned single bench. We are repeatedly trying to say you are not trying to take this. Whatever we are, that point has been rejected by the learned single bench.
One thing, Your Lordship, kindly consider how KMDA is
All right.
affected
We have heard the learned advocates for the parties on going through the impugned order. We are of the prime facie view that the directions contained in paragraph 23, 2 eyes, 3 eyes, and the order passed subsequently under the heading later, inverted comma, are clearly beyond the scope of, clearly outside the scope of the writ petition, as no such prayer was made. The learned advocate for the appellant seeks to canvass certain grounds, which for the respondent seeks to canvass such grounds, which the respondent was unsuccessful before the learned single bench. And the ultimate conclusion arrived at by the learned single bench is found in paragraph 21 of the impugned order. As long as the said order remains intact, the question of accepting the submissions made by the learned advocate for the respondent does not arise. Therefore, the order and direction issued by the learned single bench in the impugned order in paragraph 23, 2 eyes, 3 eyes, and the portion of the order under the caption latter shall remain stayed till the disposal of the appeal. If the respondent is willing to accept the lease deed in terms of the directions contained in paragraph 23 within bracket 1, he may do so by giving a letter in writing to the appellant within a week from date. On receipt of the said letter, accepting to said letter, the appellant shall execute the lease deed in favor of the writ petitioner in respect to the property in question, as directed by the learned single bench in paragraph 23 within bracket 1I, within a period of 4 weeks from the date on which such letter is issued, is submitted by the respondent writ petitioner. Next.
So far as Your Lordship state 2 and 3, 2 is the legislation, and they are carrying out these provision according of their own, my lord. This document was produced before the court by way of supplementary evidence by KMDA, and they considered that it can be transferred after the lease by this process. But Your Lordship,
you file an independent appeal, we will hear you. Next.
Item number 10.
Before my lord takes my lord, item number 10, my lord. My other side is here, item number 8. I was struck, my lord. If my lord kindly takes item number 8.
Lordship, on the last, Lordship, I beg to represent the state as one, Lordship.
No, once again, we have called out item number
10. Your item number 10.
10. Who's appearing for item 10?
Milord, I am appearing for item 10. Appellant for the item number 10, Milord. I am filing my affidavit and reply. And
you please serve copy.
Milord, I will serve a copy, Milord. We are also praying for leave to retire from the brief because, Milord, we have been instructed no longer to appear. Since it was affirmed.
Why? They want to appoint somebody else, is it?
Milord, reasons I don't want to disclose on live stream.
All right. The item number 10, the affidavit in the reply has been filed, which is taken on record. The learned advocate for the appellant submitted that he has instructions to retire from the brief. Let the matter go out of the list. Liberty is granted to the appellant to seek for inclusion after a new counsel is nominated.
Lord, may I pray for a judicial grace in this matter, Lordship?
Yes, sir.
Last occasion, my Lord, Lordship, by order dated 27 November.
Yes, that file, original file.
Original file.
You please retain it.
Lordship?
You please retain that file.
No, but this department is telling me they were having a problem because if the original file is retained with me, indefinite period.
Right. Then the learned government council is permitted to return the original file to the department and produce the same as and when required.
Lordship. Lordship.
Thank
Lordship.
you.
Lordship. Lordship.
Then next.
Item number 11.
Please come.
Sir, 11, Lord, I am for the appellant petitioner.
Yes, sir. What is this?
Lord, there has been delay of 75 days, can 1. I've explained the delay.
Delay, I think senior will not object.
Lord,
I am happy. No more delay, I'm not opposing.
Today we will
Come to
condone
your
the
lordship.
delay. Today we will condone the delay. Take up the appeal next week.
Yes. Next week.
Next week. All right, madam.
We have heard the learned senior advocates appearing for the parties. There is a delay of
75 days. Lord.
75 days in filing the appeal. We are satisfied with the explanation offered for not preferring the appeal within the period of limitation. Hence, delay is condoned, application allowed. List the appeal for admission next week in the admission list.
My lord, with your look, my lord, with kind leave of my lord Justice Bhattacharya, my lord to the Chief Justice. My lord, your lordship kindly sees we have seen the list today. It is usual list. But your lordship is taking, my lord, the matter in, my lord, as virtually. My lord, my prayer will be subject to your lordship's confirmation, the Chief Justice. My lord, in tomorrow's list, if it your lordship desires to see it in, my lord, virtually, in that case, may a note be given there, my lord, so that the entire
Actually, sir, I was supposed to come to court. I became indisposed, so I had to went to the doctor in the morning.
No, my lord.
That is the reason.
My lord, we all know it, my lord.
If
your lordship is
suppose
passing through a very hard time, we know.
No.
My lord, it is only for the convenience of the bar.
Yes.
If there is a note that your lordship will be taking matters virtually,
yes,
my lord, perhaps it, my lord.
Yes, sir. Definitely, sir. Definitely.
I beg to be appointed.
Thank you, miss. Thank you, miss.
Item number 12.
My lord, item number 12, Mr. Prolakar is appearing for the appellant and he is on his way, my lord. Kindly
Lordship,
fix
I am
the...
for the response number 3, Lordship.
My lord,
Lordship,
kindly
there is a
fix the
delay of
matter 12:30, my lord.
There is a delay of 121 days, Lordship. There is a Section 5 application, Lordship. Kindly allow me to file the opposition, Lordship.
Why you are objecting to
Lordship, because the delay has not, Lordship, it may be portraying there is a delay of 121 days. Lordship, the order was passed in the month of February 2024. The appellant for the first time applied for the certified copy in the month of May, Lordship. And after filing of the contempt by the writ petitioner, Lordship, I am not the writ petitioner herein. I am the supporting respondent of the writ petitioner. Lordship, there is not a delay of 121 days. There is a delay of 24 years, Lordship.
24 years.
Yes, Lordship. The claim was raised. This is a
Very good. Then you do one thing. You serve copy of your affidavit.
Lordship, I have served the copy. Lordship, they have served the reply copy, sir.
Yes,
Lordship.
my lord. But the thing is, the brief is not with me, my lord. Kindly fix the matter at 12:30, my lord.
No, 12:30 we will be taking up original site.
Original site. Lordship, there is a delay every time.
Then,
this is not the first time. There is a delay for every time.
Affidavit in opposition has been filed, and a reply to that too has also been filed, which is taken on record. Let the matter appear next week under the same caption.
Deeply obliged, Lordship.
Next.
Item number 13.
My lord, in item number 13, my lord, I am praying only not today, my lord.
All right, not today.
Item number 15.
This is already urgent. This is 40. This is 15. You give. Item 15.
Item number 15.
All right, not today.
Already adjourned. Item number 16.
Lord, I am for the appellant, my lord.
My lord,
on the last occasion, the Honorable Division Bench presided over by the Honorable Justice Tandon, my lord, was passed an order directing the authorities, my lord, to produce the complaint
letter.
Complaint,
Yes,
yes.
I'm submitting the complaint letter, Lordship.
You give copy to them.
Malad.
In terms of the directions issued on 13/12/2024, the copy of the complaint letter issued to the Pradhan has been produced, copy of which has been handed over to the learned advocate for the appellant who seeks to get instructions from his client. List the matter next week under the same caption.
Lordship. Item number 17.
Lord, I appear for the appellant in this matter.
Yes, sir.
I appear the
There is a section
petitioner
5
respondent.
application, my lord. There is a delay of 247 days, my lord.
Not today. Lord, in case of delay, my lord, though it is not the Lord, these things, my lord, the appeal filed the state authority and the order has been passed in presence of the learned advocate for the parties. Lord, kindly see the paragraphs should not be, my lord, the maintainable as the delay. Delay has intentionally been made. On the other hand, they have proceeded to comply the order. On the other hand, they have filed the appeal. Both the ways.
They have complied with the order.
We have not finally complied with the order. We have
proceeded to comply with the order, but they have filed the appeal. So the delay is, my lord, not the correct statement has been made in the application, delay application.
No, which is the document which shows that they have partly complied with the order?
No, that is there, my lord, in the contempt application. He has preferred a contempt
in the contempt application. They have filed the reply.
Therefore, what you could have done is complied with the order without prejudice to the right to file appeal. In the contempt application, if they are able to produce a document that steps have been taken to comply with the order, parallelly, how can you proceed?
My lord, the decision to prefer an appeal was taken prior to, my lord, taking
long after
of the order.
Long
my lord,
after.
thereafter, my lord,
Long
and
after.
thereafter, my lord,
So statement is not the
no,
correct.
my lord, my lord, thereafter, my lord, we have, my lord, taken steps to comply with the order because, my lord, he had filed a contempt application. My lord, I do not think, my lord, the matter can be heard on merit.
No. Delay, the statement is not the correct.
So whether it was a sale deed or a sale certificate, the learned judge.
It was a sale deed. It was a sale
certificate.
Auction sale deed, my lord.
Certificate on the basis of the certificate.
But this is a surface sale, sir. How 47A will be attracted? See, 47A will come in when you say that the apparent sale consideration reflected in the document is not the true and correct market value of the property.
My lord.
Therefore, the registering authority, treats the document as a pending document and refers it to the collector stamps under section 47A to determine the correct market value.
Correct market.
Here, the sale deed is an outcome of an auction sale which took place by the authorized officer of the bank who issued a sales certificate, and that there can be no doubt with regard to that consideration. In fact, I am a party to more than one judgment in the Madras High Court which said, like, assuming the housing board develops a project it enters into a lease cum sale agreement, giving the purchaser or allottee 15 years time to remit the sale consideration in installments. So that is why it is called lease cum sale. Pending execution of the sale deed, after 15 years, it will be a lessee in possession of the property. On completion of the 15th year, the authorized officer of the housing board or KMDA or whatever it is will execute the sale deed for the value of the property which was fixed at the time of allotment.
My lord.
Therefore, the question of 47A will not arise.
But in this case, your lordship may kindly appreciate, my lord. There is a play of Article 18 and Article 23.
Article 18 will not be attracted.
My lord, because, my lord, those court sales, my lord, cannot be, my lord, this sale by an authorized office under SURFACE Act cannot be in the same pedestal with those court sale, my lord. Because, my lord, these authorized officers who are selling the property is subject to correction by my lord, because there is already a judgment passed by this honorable court, my lord, by coordinate bench of this honorable court in the reference which has been relied upon by the honorable single judge. My lord, I would say, my lord, that the honorable single judge has rightly passed this order, taking into consideration the judgment passed by the honorable division bench of this honorable court, wherein it has been stated, my lord, that these 47A will not be attracted. But I am also armed with a judgment passed
what
by
we can do is
full bench of Madras High Court.
Full bench of Madras High Court is there. Division bench is also there.
My lord.
For settling the legal position, we probably admit the appeal, dismiss your stay petition, you comply with the order.
My lord, then my lord, I will have to decision.
We have heard.
I'll just humbly pray before your lordship, my lord. The rule is returnable on. My lord, we have been asked to appear on 10th. Your lordship may kindly just extend the time. We have taken steps for complying with the order. We'll need, because we have approached the concerned authority, that is the finance department, to remit the amount, my lord. We'll humbly pray for extension.
For extension of time before the single bench. We'll make an observation. Prima facie, we have heard the learned senior advocate appearing for the appellant state and the learned advocate for the respondent writ petitioner. Prima facie, we are of the view that the order and direction issued by the learned single bench would not call for any interference. However, the learned senior advocate appearing for the appellant state would contend that the legal issue raised in this appeal may be considered so as to bring clarity with regard to the legal position. The learned advocate for the respondent submitted that the appellants have already taken steps to comply with the learned single bench, the order passed by the learned single bench, and such document was produced before the court in the contempt application. In the light of the same, the prayer for stay is rejected and stay petition is dismissed. However, the full stop appeal is admitted for hearing. The appellants are at liberty to approach the learned single bench, seeking for extension of time for compliance of the order and direction issued in the impugned order.
I'm grateful. I'm grateful.
Next.
Item number 18.
18, my lord. I am for the petitioner.
Yes.
Appellate petitioner, my lord. I beg to appear on behalf of the my lord, the state. My lord, landed.
For the respondent number 8 and 9, my lord.
My lord, landed senior counsel Mr. Nilanjan Bhattacharya is appearing for the appellant petitioner, my lord, due to some medical difficulties. Not he got unable to appear before your lordship today, my lord. I am only praying for not this week, my lord.
Not this week.
Grateful, my lord.
At the request of counsel for the appellant, not this week.
Item number 19.
19, Lordship, I appeared for the appellant. Matter is relating to the unauthorized construction of the plot of land to the Devuttar property. And the suit and injunction both is pending before the court. In the meantime, the petitioner filed an application 144 proceeding. And 141 proceeding is the out of time. The learned trial judge dismissed the writ application. That there are other several complaints has been made against the state authority as well as
Sir, whether service is complete, last occasion itself, it was adjourned for that purpose.
The service is not complete as yet, my lord.
List the matter. Let the matter go out of the list and be included in the list after service of notice is completed on the respondent.
Item number 20.
20, my lord, I am appearing for the appellant respondent, my lord. I am submitting my evidence service, my lord. Without servicing the copy of the writ petition, my lord, writ petitioner obtained this order, my lord, and I am seriously affected, my lord.
What is the direction given by the single bench?
Lordship. Page 2 of the impugn order, my lord.
Page?
Page 2 of the impugn order, my lord. He would direct the private respondents to stay outside the jurisdiction of the Bora police station. But since 2011, I am in possession. I am the owner of the land, recorded owner. Writ petitioner filed preemption petition that was dismissed by this honorable court, my lord, suppressing all fact without serving the writ petition, my lord.
Why did your client not appear before the single bench?
Lordship, no copy was served before us, my lord. Without serving copy, they have moved the writ petition, my lord.
Is it correct?
Lordship.
No. We are asking your friend, the respondent. Where is your affidavit of service?
My lord, I am appearing on behalf of state.
Writ petition not appearing. I have served, my lord.
My lord, please come to the order of the learned court. Page number 7. Last paragraph, my lord. However, so far as law and order is concerned, it is for the police authority to take steps so far the issue is concerned. Thereafter, page number 2 of the order, on 5th December 2024, proceeding under section 126 of BNSS have been done by the police authorities. Please note it here, my lord. If the said proceeding have been submitted before the learned executive magistrate therein, the learned executive magistrate is directed to assess regarding the authenticity of the accusations and while accepting the bond. In that case, if he finds that there is violation of law, my lord, and ordered, he would direct the private respondent to stay outside the jurisdiction of the Burdwan police station of Murshidabad.
Ex-party order was obtained without serving copy.
No, sir. He is on a point that he was not heard in the matter.
Lordship.
That is their point. Where is your affidavit of service of notice on the writ petitioner?
Lordship, I have served, my lord. I have submitted, my lord.
Writ petitioner has been served, my lord, on 20th December.
This observation will seriously affect me, my lord.
Yes. Police, this appeal has been, intra-court appeal has been filed by...
My single bench has directed...
All right, what is your interest? Please hear this order. This intra-court appeal has been filed by the 5th and 6th respondent in the writ petition. The primary ground urged by the learned advocate for the appellant is that no notice was served on the appellants in the writ petition and an ex parte order has been passed. The learned advocate for the state submitted that no positive direction has been issued and the learned single bench has directed the matter to be appropriate proceedings to be done by the executive magistrate. However, the direction issued in page 2 of the impugned order, though not a positive direction, will definitely affect the rights of the appellant, more so when the appellant was not heard in the matter. Therefore, the order impugned shall remain stayed until further orders. List the matter after 6 weeks.
Much obliged, my lord.
Next.
Item number 21.
This is my appeal.
21, I am praying for not to remember. But this is appealing for the state.
No. This is the issue which is now pending before Honorable Justice Harish Tandon and Honorable Justice Bhattacharjee.
Yes.
And now Mr. Mazmundar, very recently Supreme Court has said even 226 it can be done.
Yes, my lord. Very recently it has been said the judgment passed by Malaysia City Ravi Kumar. That judgment says 482 and 226 they have equivalent jurisdiction.
We have to read the full judgment. All right. What is the other, Mr. Mazmundar? What is the
other? My lord, the question which falls from Malaysia's my lord Bhattacharya is this: my lord, if a interim order is being passed, my lord, whether that can be treated as a judgment in terms of section 14 of the latest patent or not.
You took time to address arguments.
Yes, clause 15 of the latest patent or not. But my lord, if your lordship sees clause 40, it's squarely applicable in our case. Clause 40 says High Court's power to entertain an inter-court appeal from any interlocutory or preliminary order.
my lord, we are, my lord, falling there.
So in this issue, is pending before the other Honorable Division Bench? No.
Yes, my lord. The same issue is
Okay.
pending before that bench.
Can you give that number?
Yes, yes, my lord. I have the copy of the order also with me. Just now, right now, I can hand over this matter.
You please hand it over to the court master. This appeal is released from the list of this court to be heard along with MAT number so and so, in which an identical issue has been raised and is being considered by the Honorable Division Bench. Let papers be placed before the Chief Justice for appropriate orders.
I think this issue has been referred to a larger, before a lordship for referring to a larger bench.
I think I've already constituted the larger bench. Let it come to me.
And my lord, in the meantime, I want an interim order because in this case, the principal accused is already been protected by the, my lord, the single bench.
Therefore, the matter will come on Monday before the other bench.
As your lordship, please.
On Monday it will come. And Monday you press for some interim protection. The court will consider.
My lord, kindly give me the liberty to do that, my lord. Kindly give me the liberty.
Yes. Liberty to move the matter before the appropriate Honorable Division.
For interim relief. For interim relief, my lord.
For necessary interim relief.
Deeply obliged.
Next.
Item number 22.
Item number 22, Mr. Basu is appearing in the matter. He's on his legs in courtroom number 5. Either grant a short pass over or make it not today, Your Lordship.
Not today.
Lordship, in this Your Lordship.
Item number 23.
Matter, I am appearing for the petitioners, for the appellants, my lord.
Yes, madam.
May I have my lord's leave to file the affidavit of service, my lord? My lord is appearing. Lord, this pertains, my lord, I am the A.H. Wheeler, iconic A.H. Wheeler, which used to run bookstalls at all the railway stations.
Yes, you said your period of license is only for 90 days.
Before we go to the I am sure Millet has gone through the papers, just for the purpose.
No. I recollect from your mentioning.
Yes, Millet, I'm deeply obliged, Millet. So, Millet, the issue before my lord is that we were always carrying bookstalls. From bookstalls, we were changed to a multi-purpose stall. As by the name multi-purpose, we were no more only selling bookstalls, but we were offering to all the passengers various articles, let's say food items, etc. Because books were dwindling in numbers. So there came a policy, which was the MPS policy 2017, and we've given the right or the option to convert ourselves into a MPS stall, which we had not accepted. Now that policy had two things. With many other things, the more important things were that it will not be extendable. And second, the term was for 5 years, not extendable. And secondly, the license fees, which was to be determined, was basis a formula derived by the zone, whereby depending upon the sales, a joint sale assessment was to be arrived at, and depending upon the sales assessment, the license fees was to be determined. So those were the two things that in the policy. That while the continuance of this policy in the term of 5 years, COVID intervened. That COVID brought in the need for railway boards to come up with circulars. Those circulars, I am today seeking for extension of my contract basis the circulars brought in during the COVID time. But that circular I'll place in details, which is at page 44.
See, earlier you had filed a writ petition where a direction was issued to consider your writ petition as a representation.
Yes.
Now, what have they done?
Millet, will kindly take the order, Millet. What they have done is they gave me 90 days before, Millet. Millet will kindly take page 112, which is the order.
Yes.
Page 112 was the impugned order before the rate court, Millet. Millet, there, they looked into all my documents. Millet, and also, Millet, very categorically, I'll take Millet to page 113, where they have held further train running in this division could not resume till 10th November 2020. We will kindly make a note of this. So that means an admission from the railways, this concerned zone, that till November 2020, there was no resumption or restoration of train running because that was a parameter for extension of the contract. Now, Millet, partial train running was resumed since 11/11/2020. So, Millet, the numbers of trains were less, and the railway board circular categorically stated that the period of enforceability of force majeure would depend upon restoration of passenger traffic at this relevant station. So my contention is that at this particular railway station, you have yourself admitted that there was a partial train running resumed since 11th November 2020. And we all know it as a matter of fact. And there is a RTI also, which I have annexed and which I had brought to the notice of the divisional manager also, who was hearing me, that it is by your own document that till June 2021, there was no full resumption of train services. Therefore, Millard, I was beseeching for grant of 434 days. Though, Millard, I came across, after filing the writ petition and before representation before the senior divisional manager, Millard, I came across numerous communications of granting of extension by IRCTC to equally placed vendors. My contention was that the implementation of those circulars cannot be differential between me and another vendor, because the railway board came up with a circular for everybody across board. Secondly, my contention was that when you have yourself not gone by, when you are saying, when you're contending that I have given you waiver and that you do not fall within this policy which was given by the railways, then the policy which you say pertained to MPS was not the policy which spoke about waiver. So you have chosen to take one clause from this policy, one clause from that policy, and to your benefit and to my detriment, you've not given me extension as granted to other IRCTC vendors at the same station. Well, let me place a contention before my lord. Then Millard will kindly will be able to understand the entire the contention which I have, Millard, here. So that's why I would beseech my lord to kindly for once come to page 44.
Madam, the shortfall is 290 days.
Yes, Millard, 290 days.
According to you, the station became fully operational, train services fully operational by June 2021.
Obliged, Millard.
Now, in this page 113, which you just read out,
yes,
they have accepted that partial running of trains, stalls reopened on 11/11, but the traffic was not much. Full strength of passengers could not be resumed after reopening. Railway board so-and-so guidelines so-and-so states that about the provision of relaxation of 90 days, namely 25/3/20 to 22/6/2020, treating at dicing on to the licensees and further relief in changing of license fee as so-and-so.
So that is the reason why I was trying to place the circulars, because here what they have
Mr. Bhowmik, once again, Mr. Bhowmik, when you are appearing for the income tax department also, you are taking advantage of 3 orders passed by the Honorable Supreme Court extending the period of limitation. Am I right?
Right, madam.
So, therefore, you accept, see, according to madam, she says there is a railway board circular. You apply it across the board. And what is he going to do in this 290 days? He is not going to become a multimillionaire. After now, he has been, his period came to an end on 20th
11th
of
November 2020. I was granted for last extension.
No, madam. Your extended period came to an end on 20th of December. Another 200 days they are going to operate for you to issue the notification, then shortlist, etc. In the meantime, you start the process.
The difficulty now is that on 20th December, this order came. The order was not uploaded till 24th December. On 24th December, we filed the memo of appeal. We could not file the stay petition, but we gave notice to my learned friend's client saying that we are preferring an appeal. I sought leave from the honorable bench, and we had filed it and had asked them that, okay, fine, in view of the order, we are not going to operate, but don't allow the stalls to be dismantled. But in that rush, between this period of the interim vacation, they dismantled my stall also. But I've been writing, I've got 4 communications where I've been always writing to them that please stay your hands for this number of days when I have already preferred appeal. But I was not able to approach my lords only because the order was uploaded only on 24th December, the last day. And because we had sought for leave.
Why did you dismantle the stall? You could have locked the stall.
My lord, kindly allow me to make my
10
submission, my lord.
stalls in total.
My lord, this is not the correct submission from the my learned friend, my lord. This is not the correct submission, my lord. First, my lord, I want to place, my lord, come to page 81, my lord. First, kindly, page 80.
What
Page
is
81. This is the first writ petition filed by them.
Yes.
First two lines, my lord. The petitioner contends that petitioner may be allowed 141 days more.
Okay.
Sir, initially we have allowed them 90 days. Then they are asking for 141 days more.
Okay.
Now, my lord, on to second line, page 82. My lord, learned single bench, my lord, honorable single bench, ask us to consider their prayer and take the decisions within 2 months. My lord, that decision of the last two lines, the decision of the authority shall be binding and rescind order shall be communicated. So against this order, they never preferred appeal. Thereafter, my lord, within that period, my lord, we have passed a speaking order. We have passed.
But then, madam, if your prayer in the first writ petition itself is 121 days.
No, may I?
My lord, I want to make 1 minute more, my lord. 1 minute more.
Yes, 1 minute, 1 minute.
1 minute, my lord. Why honorable single bench said 141 days? Because time and again they have filed an application in the department. Kindly allow us 141 days more. There is that is observed by the second order of the second writ petition, my lord. That is kindly count to second order of the second passed by the second writ petition.
Yes, page 128, second paragraph and third paragraph.
So, my lord, they have got 231 days. Order was passed in the month of September, my lord. That was made over to them on 23rd September. They sat tight. They enjoyed the entire period, and thereafter, at the fag end of the time of the completion of that period, my lord, before Christmas vacation, they came, they played victim card, and for the obtaining sympathy from this code. They could have come in the month of September also. Now, my lord, after passing this order, my lord, they have vacated their place, they have removed all their belongings, they have removed their trolleys, they have removed their tables, only structures were there. So they did not remove the structure, so we have disbanded the structure. But prior to that, they have removed all their papers, all their belongings, all their tables, trolleys, everything.
All right. Madam, how will you get over the petitioner's representation in the earlier writ petition? Restrict to 141, number one.
Yes, 2 points. First of all, in my entire writ petition, which I had placed before the learned trial judge, learned writ court also, in my entire writ petition, I have not calculated 141 days. First of all, I'll take you through my writ petition. Always said.
Then what you do is you should have filed a review.
Let 2 minutes. Let 2 minutes. Let 2 minutes. Let me kindly bear with me for 2 more minutes.
Madam, one thing. Please hear us.
I will restrict myself only to that much as my lords have been inquiring from me. Now, my lord, I have annexed to this writ petition, my lord, the 2 communications by which my learned senior friend says that there were communications made by us asking for 141 days. I have annexed them at page 125 and 126. We will kindly have a look at the date. This is 9/10/23 before I came before the writ court. And the second one is 31st January 2024. Before I came to the writ court. Now, Millets will kindly take a look at the representation made by me before the divisional manager, which was after 1st August 2024, and also the communications made to the IRCTC.
One thing you should understand.
I was not.
No, you are not hearing us. You are not hearing us.
Sorry,
one thing you should understand that the divisional commercial manager has no jurisdiction to extend it beyond the policy.
Yes,
No, madam, for 12 years I have been a standing counsel for the railways before I got elevated. We know how you contractors operate. You are virtually hijacked the platform. It's a big cartel which is going on. Don't think the court is all oblivious of this situation. And you are a big company, private limited company, and you chose to come to this court, and there is a clear recording by the single bench at 141 days. Then you could have gone before the single bench saying, Madam, this is not right. We want 400 days.
I had mentioned before the single
bench. We have heard you, madam.
The single bench then said that since I am sending it all together to the divisional manager, please address them. And therefore, my lord, in my representation before the divisional manager,
he can't, madam. He can't. We have heard yes, sir. We have heard you, madam.
There are 2 minutes, only for my satisfaction. At page 111, which was my representation before the senior divisional manager, my lord, I have mentioned 434 days because before this time, I was not aware of other days being given to the IRCTC. I was not aware, my lord. The RTI.
You are not a roadside vendor, madam. You are a private limited company. What is that?
Yes, my lord. At the same
we have heard. Please take down this intra-court appeal.
For 2 minutes, my lord.
Yes, we have heard you, madam. Sorry.
But if others being on the same platform,
file an appeal in Supreme Court. We have heard the learned advocate.
The policy did not mean that. The policy did not say that. We'll see the policy for once. We'll see the policy for once.
We have heard the learned advocate for the appellant and the learned standing counsel for the respondent railways. This intra-court appeal is directed against the order dated 2012-2024 in WPA 30141 of 2024. The appellant was aggrieved by an order passed by the Senior Divisional Commercial Manager, Eastern Railway, Sealda, dated 20th September 2024. This order came to be passed pursuant to a direction issued by this court in WPA 18759 of 2024, dated 1/8/2024. A reading of the said order will show that the appellant writ petitioner contended before the court that they may be allowed to 141 days more over and above the time already allowed to the appellant writ petitioner to continue the shop in the light of the Railway Board's notification dated May 21st, 2020. After hearing the submissions on behalf of the respondent railway, the writ petition was disposed of, directing the authority to treat the writ petition as a representation of the petitioner and dispose of the same in accordance with law upon hearing the petitioner. And a time frame was also fixed for a decision to be taken and communicated to the appellant. Thus, it is clear that the appellant was fully satisfied and their requirement was only 141 days. Taking note of the direction issued by the learned single bench, the railway authorities have passed a recent order and granted the time of 141 days. This the extended period was enjoyed by the appellant, and at the fag end, after the expiry of the extended period, at the fag end of the extended period, representations were made to the divisional commercial manager. It is to be noted that the decision to extend the time was pursuant to a direction issued in the writ petition at the instance of the appellant, who had consciously made a submission that they may be allowed 141 days more and above. Therefore, the appellant cannot eternally continue to be a licensee of a multipurpose hall in a railway platform, and there is no vested right for the appellant. That apart, the grant of such licenses are public largesse, and therefore competitive bidding has to be followed by the Railway Board, and for such purpose, the Railway Board has formulated a policy. Therefore, we find no ground to interfere with the order passed by the learned single bench, and accordingly, the appeal fails and is dismissed. It will be open to the appellant to participate in the tender, which may be called for by the railway authorities.
So the fact that 141 days was not my contention before the writ court, I can demonstrate in another writ petition. In another writ petition, which was where Mr. Bhomik was not appearing. Sorry, the court has mentioned 141 days as cyclostyle. It was not my contention, not even from one paragraph.
Madam, you should have filed a review, madam, then.
But because I had mentioned to the Honorable Writ Court, the Writ Court was of the view since I sent the entire matter to Division Manager.
Madam, we can go only by what is
That is the reason why I was praying for 436 days before the manager. In
Yes,
my
madam.
representation, it is 436 days.
We have passed the order, and it's up to you to
But
next.
even the license we get,
Item number 24.
24.
I'm obliged with it.
Deeply obliged, my lord.
Yes, sir.
My
24.
lord,
Item number 24, I am appearing on behalf of the respondent number
this is
10.
the usual matter, my lord, that well, just one petition was moved before the magistrate.
Mm.
163 now, obtain certain order, in action police, move high court. I'm not blaming the court below, my lord, and got an order. And the most interesting thing is this, my lord, knowing fully well and blaming my club, I am not been implicated as a party. Order is passed. What is the fact here? My lord, my club is a registered club. Not only that, not like other clubs by showing the muscle plans to grab the property. They purchase a portion of the property, enjoying this property. They are really bona fide purchasers of value. Now, my lord, Mr. Other side, my petitioner, he also purchased a portion. No problem. The my lord, he initially filed a suit for declaration which was dismissed. That was not disclosed in the writ petitions. I also filed a suit for partition that has also been disclosed. There is an order of injunctions. Just against that particular in connection with that matter, I'll place all this order, my lord. If the sanction is legal, that can be constructed. Whether legal or illegal, that is yet to be adjudicated. Because on the common passage, he is making the construction. He suppressed everything before the court below and got an order. And taking the advantage of that order.
And who will appear for the Gram Panchayat?
My lord?
Who appears for the Gram Panchayat? Because the learned single bench has recorded.
No, we have served.
Since the learned single bench records that since the sanction plan has been granted by the concerned Gram Panchayat, police authorities should ensure that no obstruction be created while raising construction at the behest of the petitioner. In case any untowardness, police authority abandon precaution.
That was the report submitted by the police authorities.
Kindly, just a minute. My lord asking me, I'm arguing. So, my lord, had it been a case that well, I was implicated as a party because in the petition allegation.
You are not a party in the petition.
No. And Supreme Court is very candid. I have just shortest judgment, just one page. If the party is not made a party, relevant party, that should be order should be squashed. There's one page judgment, my lord.
Yes, sir. Yes, Mr. Banerjee, what do you say?
Yes. Milord, my learned senior friend's client, Milord, is not at all, Milord, having any semblance of interest, Milord, in my property, which, Milord, I purchased, and the property was, Milord, bartered and bounded with particular boundaries. Milord, the land which my learned senior friend's client, Milord, is claiming, Milord, to have an interest in, is, Milord, completely different a land altogether. My learned senior friend is today referring, Milord, to a partition shoot where, Milord, he has obtained, Milord, an order. Milord, that order, Milord, was a counter product of the sanction plan. The sanction came first, the construction commenced first, then Milord, writ petition filed, then Milord, the suit was instituted, and Milord, they made a suppression that everything has happened, and Milord got, Milord, clandestinely, Milord, an order from the learned trial court. Milord, may I show, Milord, my title deed and my learned senior friend's title deed?
No.
Now make my
in my
submissions.
petition, I've annexed.
Milord, yes.
In my
kindly,
petition,
Milord, just have a look.
Disclose.
Kindly just have a look at page 32
one thing. Now, if there is a suit for injunction filed and an injunction has been granted, you could have implemented him as a party and taken an order in his presence.
We have filed a suit and the declaration suit is dismissed.
By
this time, the construction is made. My lord, by this time, if such an illegal construction is made, being encouraged by an order, my lord, this is really unfortunate. I have annexed all the documents. My deed, their deed. Nowhere the plot number is mentioned in his deed. My deed. Kindly have a look to my petition, my lord. Just one page. In my petition, nothing has been disclosed. I have annexed my deed.
But their submission is that the sanction was obtained earlier.
Yes. That's on record.
No. Sanction.
I can show here and
kindly appreciate. No, let me explain. My lord asking me something. Kindly appreciate. I could have understood, my lord, that a sanction. That's why consciously both the court, magistrate, and the Honorable High Court mentioned legal sanction. Kindly see the word.
Let him
In
challenge
the order
the
itself,
sanction
legal
plan.
sanction.
All
He
right.
does not
No,
challenge
no.
the sanction plan.
Before we pass any order, we have to hear the Gram Panchayat.
Yes, my lord, kindly hear.
And who appeared for the Gram Panchayat before the single bench?
My lord, I'll just check.
I serve the notice.
No, any advocate name is there?
No, my lord, they
Nobody
were not
appeared?
represented. They were not represented. State was represented.
Or OVS is
State
they
made
didn't
a
appear.
submission that my lord, police had gone there. Police, my lord, inquired, my lord, spot inspection. Police had also visited my lord, Panchayat office. My lord, took notice of the my lord, sanction plan, which was my lord, available in Panchayat office.
Everything was done
submitted a
behind my back.
report.
If you are so sure, why you have continue the suit?
My lord, these
You
are all
file the
assumptions,
declaratory suit.
wild
No, I have
assumptions.
annexed. I have annexed the order.
All, yeah, my lord, may
No,
I
no,
give
You
no.
file this. You file the declaratory suit.
No, no. What we'll do is, you once again serve the Panchayat. Whether any state advocate can appear for the Panchayat?
Yes, my lord.
It's all
Mr.
depends.
Ansar Mondal, my lord, appeared represented the state
I do not
government.
know.
My lord, I can put him on notice.
We have served him notice.
My lord, I'll
All
supply, my
right.
lord, serve him on
And I am
notice.
not even influenced the party.
The learned advocate
I'll
for the
place
appellant.
everything. Yes, I have to annex all these documents.
All right.
To the property.
Learned advocate for the appellant is directed to serve notice on Mr. Ansar Mondal, who appeared for the state in the writ petition, and Mr. Mondal shall obtain appropriate written instructions from the Gram Panchayat. Which Gram Panchayat?
Champahati, my lord.
Champahati Gram Panchayat.
We call it Chapahati.
Champahati.
Oh, Champahati.
Champahati Gram Panchayat has written instructions on Champahati with regard to the full facts and the rights of the parties over the property in question. The rights of the parties, namely the appellant herein, as well as the writ petitioner.
So grateful. So grateful.
And next Thursday in the admission list.
And declaration issue was dismissed. That was filed by him. If you are so sure about his position, why did you not register and continue? But it is nothing but the muscle power. That's our problem. And this is the usual practice. Just moving at 144 applications. Then
is complaining of muscle power.
Yes, because we are the bona fide parties for value. We have purchased. We have purchased.
Grateful.
Yes, sir. Now we will go to the original side list.
My lord.
Yes, sir. We are now switching over to original side.
May I leave my lord?
Yes, sir. Thank you.
Grateful, dear lordship.
Original side mentioning?
My lord, may I be permitted to mention a matter, my lord? In this matter, my lord, your lordship was pleased to dispose of the appeal, but my lord, the original order is missing in the file. My lord, unable to obtain the certified copy, my lord. It is not available in the file, my lord, original order.
What should we do?
My lord, because they want to file SLP against that, not so certified copy here is unable to get the certificate because they are saying that the original order is not in.
Which one, Mr. Doria? Item number 1, the appeal was admitted.
No, item number, not item number 1. I'm mentioning.
Mentioning is it? All right. You give the number.
My lord, I'm great.
What about item 1?
Yes,
Item number 1, Your Lordship, it has come at my instance. Your Lordship, this appeal was admitted by an order dated 6th November. Your Lordship, subsequently, the assessee intends to approach the department under the direct tax Vivad Se Vishwas scheme of 2024. So, Your Lordship, I'm praying if I may be allowed to withdraw the appeal with the leave that in case the Vivad Se Vishwas scheme does not go through, my lord, I may be allowed to come back to the Honorable Court, Your Lordship.
Yes. We have heard Mr. Pratyush Jindal, learned advocate for the appellant, and Mr. Amit Sharma, learned standing counsel for the respondent. The appellant seeks leave to withdraw this appeal with liberty to approach the respondent under the Direct Taxes Vivad Se Vishwas Scheme 2024. One more prayer is made by the learned advocate for the appellant that in case the appellant is unsuccessful to resolve the matter under the settlement scheme, the appellant may be given liberty to restore this appeal and contest the same on merits. The appeal is dismissed as withdrawn with liberty to the appellant to avail the direct taxes so scheme 2024. And in the event the appellant is unsuccessful to resolve the issue, liberty is granted to the appellant to file an application for restoration of this appeal and this appeal would stand restored and to be heard and disposed of on merits.
I'm deeply obliged, Your Lordship.
Next.
Item number 2.
My goodness, 1433 days. We have heard Mr. Amit Sharma.
My lord, there's one embarrassing situation for me. Service is not completed, my lord.
That is enough, sir. Yes, on, sir. There is a delay of 1,433 days in filing the appeal. We have perused the averment set out in the affidavit filed in support of the petition, and we find that the explanation offered is wholly unacceptable. The delay being inordinate and unexplained, we are not persuaded to exercise any discretion in favor of the appellate department. Accordingly, the application is dismissed. Consequently, the appeal stands rejected. Next.
Item number 3.
My lord, there is a delay of 198 days, my lord.
There is no problem. That Mr. Mazmundar will not object.
No, I will not opposing, my lord, the delay.
Well, that they won't object. Sri Leather, share application money.
From paragraph 15 onwards
of
the tribunal judgment, paragraph 17, my lord, the learned tribunal has quoted the observations and the findings arrived at by the learned CITA. Lordship will find that everything was accounted for, even the shared applicant was regularly assessed, subjected to scrutiny assessments from time to time. This, I fail to understand. This is,
my lord, let the delay be condoned today. On the next date, I will make submissions on it.
My lord,
I have something to submit, my lord.
All right.
Right, my lord.
You heard Mr. Amit Sharma, Mr. Mazmundar.
My lord, I am also there.
Ah, yes, Mr. Vipul Gundali.
No, my lord.
Since he started this.
No, item number 3.
Okay, no, I'm not.
I'm led by my Mrs. Dasde, my lord, in this matter.
All right. Smita Dasde, Amit Sharma, Mr. Mazmundar, along with the Smita Das and Siddharth Das. There is a delay of so and so days. As the delay has been properly explained, the same is condoned. Application allowed. Next.
Grateful.
I'm grateful.
For admission, item number 4.
No delay. Item 4, who will appear, sir? It is actually a common order passed in 9 appeals. Only one appeal is filed. Who filed that? Tapan Banja, is it? Om Prakash Prasad.
SSC's appeal.
SSC's appeal.
None is appearing here, madam.
All right. None appears for the appellant. List after 2 weeks.
Item number 5.
Lord, I appear in this matter on behalf of the appellant. Lord, the case is very simple in the sense that, Lord, I was.
Mr. Sengupta, can we take it up next week?
Lord, only thing is this. And it relates to, Lord, renewal of passport.
Passport, yes. I remember this matter.
Lord, and your lordships were kind enough to say that this can be heard out at the, as to be mentioned. So it appeared in the list. Now, Lord, when Mr. Additional Solicitor General wanted an adjournment.
This is appearing for admission. Whether this
Kindly see the order.
interim order can at all be interfered with. That is the question, my lord.
Yes.
Lord,
Now,
kindly see the order. First
no,
order.
actually, we have said at this stage itself, we will hear out the appeal.
That's right. That's what I say.
We will adjourn it like because now let the appellant also be in Calcutta. The weather is very good. He can stay here for some.
Lord, only thing is, may I just indicate 2 things to your lordship? Number 1, my lord, under the law, I have to take permission of the court where the criminal case is pending.
Delhi High Court has granted.
Delhi High Court and NIA Court at Ranchi. Both have granted permission.
No, no, my lord, my learned friend is not saying anything. Conviction order passed has not been stayed. And this
All right, we will hear out the matter after 2 weeks, sir. Not now.
Lord, kindly do not do that, Lord. Kindly keep it next week.
All right, next
First
week.
matter.
Next week. Next.
Item number 6.
What is this recalling application?
My lord, in this matter, my lord had passed order dismissing my application, my appeal. My lord had dealt with 2 grounds. My lord, I am coming before my lord as there were several more grounds that were there in the appeal. My lord will kindly see page 4.
But then it should be by way of a review. We can't recall this order. This has been signed, uploaded. It's become a judgment.
Yes.
You should file a review. Suppose there is an error which is apparent on the face of the order.
Right.
You will have to file a review.
My lord, this is what I had also discussed with my learned junior.
This application has been filed to recall the judgment passed in this appeal dated 19th of April 2024. The said judgment has been signed and uploaded and has become final. And an application for recalling such an order would not be maintainable. Accordingly, application dismissed. You discussed with the department also.
My lord, if my lord puts in one word there, it should have
No,
ought to have been
that they will object. That they will object.
My lord. Item number 7 and 8.
Delay has been condoned.
No, 7 and 8, it's a very short matter. It can be done in my humble submission in 15 minutes time.
Sir, I got some administrative work to do at already registrars are waiting here. So let it remain in the list. We'll just say not today. Next.
Number 9.
Number 9, my lord, this is my appeal. My lord, I'm handing over the affidavit of service. Now, my lord, the appeal arises out of an order passed in a writ petition whereby the learned honorable single judge, my lord, has dismissed the writ petition on the basis of the report filed by the CSC authorities. Now, my lord, what happened, my lord, I filed a writ petition wherein, my lord, I prayed to removal of the feeder box, my lord, which is installed in the passage, my lord, private passage, my lord, leading to my premises, which is causing difficulty in the ingress and egress. Now, my lord, if my lord takes up the application for once, my lord, prior to taking up the impugned order.
The learned single bench says there's some technical difficulty.
Yes, yes.
But how we are to resolve? You suggest to us how
No,
this
my lord,
technical difficulty.
yes, my lord, I tell your lordship, my lord, if my lord takes up the application for once, my lord, page 105.
Yes.
Now, my lord, this is the report, my lord, on the basis of which this impugned order is passed. Now, my lord will find this report is on the basis of the pillar box. Now, my lord, if my lord turns over, my lord, to the photograph which the authorities have annexed at page 108. My lord, this is the pillar box on the SN Banerjee Road, which is a municipal footpath. My lord, I have no issues to that. My lord, what my issue was, my lord, constrained to, my lord, if my lord takes up the photograph at page.
No, sir. Sir, you want the pillar box which is in the footpath?
No. My lord, my writ petition is removal of feeder box. Kindly takes up page 101. My lord, this was the annexure in the writ petition, my lord. The blue box, my lord, will find in the photograph. 101.
Yes.
My lord, the blue installation.
My
lord, this is a feeder box. And my lord, in the footpath is the pillar box. My lord, I want this passage, my lord, is causing my vehicle's movement, obstructing my movement. This is a private passage. My lord, I wanted removal of this box. The report entirely is on the pillar box, first of all. My lord, pillar box in front of this premises is that footpath, my lord, which is approximately 10-12 feet wide, my lord, over which that pillar box is there. My lord, the report says the lines are drawn, my lord, the areas are drawing electricity from the pillar box. So well, my premises also, my lord, drawing electricity from that pillar box.
No. The learned single bench also was of the view it's the pillar box.
Yes. So, my lord, feeder box was never under consideration, and the report comes on pillar box. My lord, when I
All
objected.
right, let us ask what CESC to, what is your, it is obstructing his passage, sir.
But this is the case, your lordship will find this is unnecessary interruptions from the petitioners, now the appellant. Now, what happened if your lordship kindly peruse the report, your lordship will find these things has been done in the year 2009 onwards. At that point of time, no objection has been given. An admitted fact that this is within the municipal road, and my learned friend is trying to obstruct this. What happened, lordship? He is one of the co-owners. Other co-owners never objected that. In the
That
year
is correct, sir. Sir, you please come to page 101. It is a private passage. It is not on a road. A prima facie. Subject to what your officer, that blue box.
But this is not the private road. This is the municipal road, lordship. And even the municipal authorities.
Municipal road, you can't block the municipal road like this. Either you shift the feeder box closer to the, now latest technology has come. This is some archaic box exposed to, the fury of weather. Dangerous for the people who to walk.
I tell you, lordship, in pursuance to the direction given by the Honorable High Court, we have made inspection in presence of the petitioners, and we have seen that we have tried to find out any alternative place. But there is no other alternative place, and it is for the public interest. This line has been granted to the
correct. What you can do is, now the equipments, latest equipments are there. Earlier, we used to have big main boxes in our residence. Now they have all become very sleek and thin with circuit breakers. You make a feasibility study and give the cost. He will pay the cost. If it is 5 lakhs, 10 lakhs, he will pay the cost.
It is catering to the whole locality. At present, there is no alternative place at this juncture since 2009.
On the wall of that passage, because it is upstream. Please see page 101. I don't know whether you have been given color photographs or black and white.
But from these photographs, it cannot transfer that whether it is a blockage or not.
No. What is all this, sir? Please come to page 96.
Let us take a further instructions on this matter, lordship. Yes,
examine, see. All right. You have heard the learned advocates for the parties. It appears that the learned single bench was of the view that the appellant seeks for shifting of the pillar box, whereas the appellant's prayer is to shift the feeder box, which is situated in a passage.
One thing, lordship, just now I have taken the instruction, the feeder box and the pillar box is the same thing, lordship. Same thing. But what my learned friend submit is not correct.
All right. Prime facie, from the photograph at page 96 of the stay petition, we find the feeder box to be projecting into the passage, which according to the learned advocate for CEC is a municipal passage. In any event, if the feeder box is projecting into a passage, there is chances of people getting electrocuted, and the feeder box appears to be an old installation. Given the present day technology, CAC may examine as to whether an alternate arrangements can be made so that the pillar box does not project into the passage, subject to the condition that and if found feasible, the appellant should undertake to obtain no objection from all the other residents of the locality, since power supply may be required to be disconnected. Apart from that, the appellant should agree to pay the entire cost of such alternate arrangement. List the matter after 2 weeks. A report in the form of an affidavit be filed by the appropriate authority of CEC Limited after 2 weeks. Next.
One thing, lordship, let them also show that there is any alternative passage place or not.
We have shown
they could not show that. Even
in order to facilitate the compliance of the above direction, the respondent CEC Limited is directed to fix a date for inspection and put the appellant as well as the other residents in that area on notice with regard to the inspection to be done. Next.
At the time of the inspection, the notice will also may given to the Kolkata Municipal Corporation.
CEC Limited shall also inform the officers of the Kolkata Municipal Corporation so that one officer may be present during the inspection.
May I pray for one indulgence? Kindly fix up a date and time here right now because the appellant is also here. Kindly fix up any date as well so that
you suggest a date. Your officer is behind you. Ask her to tell the date.
Next Wednesday, Lordship, subject to Lordship kind of.
All right. As it is submitted by the Learned Council for CEC Limited, that the date of inspection may be fixed by this court. Accordingly, the consent of parties, the inspection be conducted on 15th of January 2025 at about 11 a.m.
12, Lordship, kindly make it 12.
At about 12 noon.
I am sorry, Lordship, kindly. I'm deeply obliged.
Next.
Item number 10 and 11.
Well, I appear for the appellants.
Yes, sir. Delay has been cut out.
Yes, ma'am. But before Advocate General start, 11 is in respect of a different scheme. So 10 and 11 different.
My lord, I am appearing for my lord this respondent. 11, my lord, I am not in that matter.
Who is appearing for respondent? 11.
In 10,
I don't know 10.
Item 10, I am appearing.
Sir, 11, there is a delay of 346 days.
Yes.
11, my lord.
And your counsel on record can take instruction on that 11 also.
My lord, I am for the 11, my
lord.
But 11, my lord, state has also preferred an appeal. My lord, it's in a different scheme. So, my lord, kindly adjourn this matter 11. We'll come back with instructions. And 10, my lord, Advocate General is appearing. Item number 10.
10, we'll have it next week. 11, we'll adjourn it by so-and-so accepts notice. Item 11, so-and-so accepts notice for the respondent. At request, list the matter. After 2 weeks, you give a date for 11. Yes.
No, 11. My lord, 10, the rule is returnable on Friday.
My lord, there is no appeal by the state against the impugned judgment and order, and the rule is directed to the state respondents, not to the appellant.
They will know. Advocate General knows how to manage.
There is no rule against any official of WBIDC being the appellant before your lord.
Thank you.
Subject to correction by Learned Advocate General and all his judgment.
You are correct, sir. They are not objecting. Next. Next is, that's all, huh?
That's all.
I don't know what 12, man.
12. What is 12?
10.
Next week.
12. Who will appear for 12?
I am for the appellant.
Not today. Yes, Mr. Agarwal.
My lord, for next 15 days, I will not be here. I am going on religious trip, my lord.
Very good. Please pray for all of us also. Please pray for the High Court, all your friends, all the honorable judges, staff members, officers.
For the entire country.
All right. Well, then what we'll do is, we'll fix it on
maybe in the monthly list of February.
February. I'd request monthly list. That's all.
Item number 13.
Item 13.
Item number 13, I am appearing for the respondent.
Where is this assessee's appeal?
Yes, there is assessee's appeal.
Oh, your appeal was allowed by the tribunal.
Yes. Well, your lordship, kindly see, nothing is.
All right, Mr. No, we'll wait. Mr. Subshankar Ghosh appeared for the.
But last occasion also they have not appeared, your lordship.
No, earlier round, Anil Dugar had appeared and Rashri Chatterjee. Can you inform that none appears for the appellant? List next week.
My lord.
Item number 14.
This is my application, my lord. Your lordship, the question of law at page 6. The
Respondent has
Your
been served.
Lordship, yes, yes, my lord. Delay has been condoned also. The main issue is with regard to the addition on account of the unexplained purchases, my lord. Now, if your lordship kindly takes up the order of the tribunal, it starts from page 74, and the lordship kindly comes to page 75, paragraph 3, my lord. That is the submission made by the departmental counsel, my lord. May I place it? After hearing the learned DR, we are of the view that there is a merit in the contention of the learned counsel for the SSC, and in this case, admittedly, the SSC is a trader, and the sales have not been doubted. Even the source of the purchases has also not been doubted. The only dispute is that the genuineness of the actual purchases made has been doubted by the assessing officer. Considering the aforesaid facts, a reasonable conclusion will be that the SSC might have suppressed some profit element by showing the purchases at a higher rate. The learned counsel for the SSC has submitted.
So, madam,
Yes,
once
my
again,
lord.
the tax effect in this case is 5,63,000.
Yes, but we have indicated page 7, my lord, paragraph 16 of our application, that in spite of the tax effect being much below the prescribed monetary levy, but we are preferring it is only which it falls under the exception clause 3H
All
of
right,
CBDT circular number
where
5.
is your affidavit of service?
Affidavit of service already filed, my lord. On the last occasion, it was.
Before the Honorable Justice.
It's on record, my lord. It's on record.
Who appeared for the SSC?
Nobody had appeared.
Nobody had appeared.
Nobody appeared. Actually, can you inform this advocate? What is it? Somnath Ghosh.
Somnath Ghosh appeared before the tribunal.
Yes. The learned advocate for the appellant is directed to inform Mr. Somnath Ghosh, learned advocate who appeared for the SSC before the learned tribunal. List after 2 weeks.
The next matter is same SSC, different assessment year.
All
It's
right.
emanating from the same tribunal's order, my lord.
Same one.
Yes, ma'am.
So we will stop with this.
Yes, Lord.
Yes, sir. Thank you, sir.
My lord, item 17, my lord, may be taken up in the after 3 weeks, my lord. Item 17.
Please give a date.
Yes, Lord.
Items, whichever is convenient.
Yes, Lord.
I tender my apology for not appearing in item number 3, coming all the way from 7:59, my lord.
All right. Thank you. Thank you.